Well, it's now my pleasure to introduce our keynote speaker to close the conference, Chris DeMuth. He has a very distinguished record, as anyone who has perused the materials for the conference knows. Graduate of the University of Chicago Law School. He's been in the business of observing and participating in regulatory reform for a very long time, and so he's ideally situated to give a talk on moving forward with administrative procedure, because he was the person at the helm in the great experiment of trying to increase presidential oversight of the regulatory system as the head of OIRA under President Reagan, and the person who brought Executive Order 12291 to fruition. Then he spent, about 30 years as president of the American Enterprise Institute, stepping down just a few years ago, and now is a fellow at the Hudson Institute. But what really matters is that he was my first, I'm not going to call him my boss, I would say he was really my first client. Off of my clerkships, I was Assistant General Counsel at the Office of Management and Budget, and most of my time, I would say, was spent working with Chris on regulatory issues, and I got quite an education in the ways of Washington in those times. And I want to say I've worked with a lot of very impressive people, very statesmen of considerable stature, but in my career, I have never had the honor of working for somebody I was as completely convinced spent every moment devoted to his understanding of the common good as Chris DeMuth. That I have, one might agree or disagree on policy questions with Chris, but I never had the slightest doubt that he was really interested in pursuing that. And so it's just such an honor, some 35 years later, to be able to introduce him as our keynote speaker.
Mike, thank you very much, and thank you for inviting me to speak to this very formidable group, and to spend a few days learning from all of you before I get up to say a few words myself. I've been asked to talk about an APA for the 21st century, and a prescription for reform of that very durable and robust statute requires that we take symptoms and complaints and translate them into some form of differential diagnosis. And I've noticed that the range of professional opinions on the subject is very wide. If we ask Phil Hamburger, he will say that the APA in administrative law was a terrible constitutional wrong turn. We should abolish the whole thing, at least as it was written in 1946. If you press him, and I have, he will say that what we need to do is for the Congress to march systematically through the entire code of federal regulations and moving it over to the United States Code, moving it into statutory law, while culling, revising, reforming its individual provisions as we go along. Those with any sense of the length of the CFR know that this would at best give us an administrative law for the 22nd century. As I read Jerry Mishaw, Daniel Ernst, their books, they regard the APA and administrative law as admirable adaptations of ancient legal and constitutional norms to the modern world. They see few problems and would probably be content with a few tweaks. My prescription, which I'll get to in a few minutes, will be intermediate between those, but I think I'm not splitting the difference, that I have a distinctive diagnosis, And let me say that I'm going to be focusing on government rules and orders that direct the conduct of persons and organizations in their otherwise wholly private capacities. So I'm not concerned with internal government organization or relations with the states or employees or contractors or grantees or grant seekers or individual beneficiaries such as under the food stamp and Social Security disability programs, but pure regulation, what people generally mean by federal regulation. My diagnosis is that the administrative law that we have in the first 14 years of the 21st century, that which was fostered by the APA and nurtured over the decades, is pathological in three respects. First, it is too powerful and unconstrained. Second, it is too specialized. Third, it is too crummy. My first, that it is too powerful and unconstrained, begins with the core problem that has been discussed very much today of the executive unbound, of the accumulation of essentially unilateral lawmaking power in the executive branch of the federal government through progressively more expansive delegations from Congress, essentially from 1970 through the present, through the court's abandonment of even the pretense of a non-delegation doctrine, and many highly deferential canons of construction of deference to administrative agencies, Chevron and the like, through intermittent seizures of extra statutory authorities by agencies and by presidents, through the progressive realization of the APA's amalgamation of fact-finding, lawmaking, surveillance, enforcement, and in recent years, even political representation by executive agencies. I'll say more on that last point in a minute. And through the sheer superior efficiency and dispatch of hierarchical executive action over legislative action or judicial action. Our constitutional system relies upon competition among the three branches to police against abuse and corruption, and to induce moderation and compromise among differing and often conflicting conceptions of the public interest. I think that we are losing this. There are many plausible episodes of corruption and abuse in recent years. I have in mind the IRS, at the Veterans Administration, two cases of unilateral action which are completely unilateral in that the agencies actually raise and spend their own money. The FCC's Universal Service Fund that Mike Grieva alluded to, and also the White House's own BP Horizon oil spill compensation program, have both been rife with scandal and abuse. Occasionally one sees people like the Sacketts in their Supreme Court case 2 years ago who are squished by agency stratagems. By the way, that was a 9-0 case. The Sacketts still have not come anywhere close to getting a hearing from EPA. They will never build their house. EPA will see to it that happens. But specialized professionals, especially those who focus on the most powerful agencies, which are the FDA and the SEC, can rattle off lots and lots of cases like this. People on the inside know that it happens all the time. A separate, less recognized aspect of unconstrained power is decision-making in the absence of more than a very weak resource constraint. With regulation, taxing and spending is done all in one swoop. The resources, the costs, and the benefits are realized almost entirely within the private sector, unconstrained by the layered disciplines of public finance. Taxing by regulation, just like taxing by legislation, itself is costly and contentious. I acknowledge that. But taxation by regulation essentially takes the form of invisible, politically insalient sales taxes. The real costs are paid by consumers who are not part of the rulemaking proceedings. Moreover, those costs are tied to benefits that are highly popular in most cases, and to many possess a very strong ethical component. The result is that rulemakers in big rulemaking proceedings are largely free of the economic constraints that force trade-offs among competing goods, that establish rough baselines for judging the effectiveness of what they're doing, for providing some inducements to internal efficiency. It is an apolitical fact of life that doing one thing necessitates not doing something else. That reality intrudes only weakly into the pursuit of the regulator's mission. Specialization is a great boon. It is highly advantageous. It is the key to modern prosperity, economic advance, scientific advance, and also under the fancy term expertise, it is a key tenet of Woodrow Wilson progressivism, that is the intellectual foundation of the administrative state. I acknowledge the utility of expertise and specialized lawmaking in certain technical areas such as food and drug regulation. But we now have a highly specialized law operating in many hundreds of purely routine, quotidian, but very, very narrow crannies of commerce and social life. The regulator may or may not be captured by industry, by organized groups that support its statutory mission, by others. But the regulators are certainly, and in almost all cases, part of the same culture. The regulators and the regulatees form a culture, and a highly insular culture, especially when one of them, the regulator, is possessed with relatively autonomous power to keep the group together. And these cultures can easily become self-referential, dysfunctional, can go off to extremes. Specialized lawmaking is a special problem. This was conspicuous in the decade before the financial collapse of 2008, when the banks, the bank regulators, the mortgage promoters, Fannie Mae and Freddie Mac, and others who were part of this game, talked themselves into a set of propositions about capital standards, leverage, mortgage lending standards, risk management through technical diversification techniques that in retrospect were utterly preposterous, and were preposterous to some people at the time who were observing from the outside. Similarly, the Bernard Madoff scandal was something that the SEC was completely oblivious to, a huge fraud with fingerprints all over it, and which some people on the outside did see. But Madoff he was part of the team. He was part of advisory councils. He was an insider, and he was part of this same culture of specialized lawmaking and the routines which he mastered and then took advantage of. By too crummy, I mean, I want to acknowledge, let me say that the policies and the programs that operate through administrative law, there you can find pockets of excellence. You can find pockets of Bill Simon's aspiration of the ideal of, as he put it, ongoing inquiry and correction. You can find that this happens. But the system as a whole is highly ineffective, unproductive, often perverse and counterproductive, a font of unintended consequences. consequences. Regulatory programs tend to be highly resistant to experience, evidence, and feedback. The programs have this odd combination of being both very sluggish and very harsh, all of which, in my judgment, go beyond the conventional relaxed standards that we apply to government work. I think of policy failure as the greatest problem of the administrative state today, that it is so wasteful and that in the name of many, many important causes it produces so little. I'm going to leave the details, however, to Peter Strzok's wonderful book, for those of you who haven't read it, which goes into these matters in great detail, and would add only that I think that his litany of the causes of policy failure that he identifies, having to do with the nature of our political institutions and our political culture, are exacerbated by the problems that I have homed in on. That is, that we have policy through a proliferation of insular policy silos, each one possessing an enormous amount of autonomous autonomous political power, acting under only weak resource constraints that provide incentives for improvement. In thinking about the practical possibilities for reforming the APA to address the problems that I've identified, it's important to consider how the past efforts at reform have fared. The first problem of concentrated power and the amalgamation of constitutional authorities, this problem has inspired repeated reform initiatives from the American Bar Association, from other lawyers' groups, from good government groups, the Hoover Commission, from a variety of business organizations, going all the way back to the beginning, going all the way back to the early 1950s, and continuing down through the present day. Reform proposals such as establishing a corps of independent ALJs to hear cases who are not employees and don't go to the same lunchroom with the people in the agencies, for establishing higher court-like standards of evidence, for the formalization of rulemaking proceedings through live hearings, opportunities for cross-examination, and so forth. Not one of these proposals, since the APA was enacted, not one of them has been enacted, with one itsy-bitsy little exception, which was the banning of ex parte communications and formal adjudication, made in the early 1970s when formal adjudication was fading in importance, being pushed aside by rulemaking and informal adjudication. Instead, here are the amendments that Congress actually has passed to the APA. The Freedom of Information Act, the Government in the Sunshine Act, the Federal Advisory Committee Act, the elimination of sovereign immunity in cases other than those seeking money damages, the Regulatory Flexibility Act with a little bit of some procedural sops to small businesses, and the negotiated rulemaking amendments. What do these, and all of the while, Congress has been giving the agencies more and more discretion. So what they've essentially done is to ignore the ideas to make administrative law more law-like, protective of specific defendants and so forth, but required it to be open, porous, transparent, non-opaque. At the same time, the courts have been asked to curtail congressional delegation and agencies' discretion repeatedly. For the most part, they have rejected those pleas, with some departures, but many of those departures, such as State Farm and Massachusetts versus EPA, recently the first of the greenhouse gas cases, have actually increased agency discretion and prerogatives as a result. Instead, they have insisted that the agencies be open and porous, transparent, and in particular, rational, or at least rationalistic. That is, that they provide detailed explanations, going far beyond the APA's requirement of a concise statement of their decisions and of their evaluations of evidence and arguments submitted by all of the parties that happen to show up for their notice and comment proceedings. The result of both of these concurrent and parallel trends from the courts and from Congress is that the administrative state has very wide lawmaking discretion conditioned on observance of democratic norms. That is, with it being open and porous, and using notice and comment the way a legislature does to assemble a coalition which will stick to some extent with their decision, with the duty of rational explanation substituting, as with the courts themselves, for the lack of an electoral warrant. It is a program, it is a form of government that may be called ad hoc, non-electoral, administrative democracy. It possesses enormous political potency and motive force. This history suggests that the prospects for ABA reform are pretty slim, but there have been several recent developments that may point to new openings. First, the breadth of delegation in recent years has become quite breathtaking, essentially under the Affordable Care Act and the Dodd-Frank Act. The Affordable Care gives the Secretary of HHS the power to set prices for health insurance companies with absolutely none of the procedural findings, any of the protections which were conventional in all of the New Deal and progressive statutes. If you read the statutes, you can just announce what their prices are. There are other cases. If you look at the standards that the Financial Consumer Protection Bureau, it's essentially supposed to ensure that every American has access to fair and competitive financial services. The rest is up to them. And there's this amazing innovation alluded to once or twice of setting up these odd little mini legislatures, these little commissions and councils within the government, such as the Financial Stability Oversight Council under Dodd-Frank and the Medicare Payment Advisory Council under the Affordable Care Act, that make decisions of enormous magnitude by majority vote. So they look a little bit like some of the old New Deal commissions, except there's no proportional representation. There are a couple of odd things, such as I think FSOC has somebody that the state insurance commissioners, but otherwise they're all vote, and the head of the Federal Reserve Board. But otherwise they're all appointees of the administration, but they're kind of acting as if they're a legislature, which makes whatever the rules of appeal may be, makes it more difficult for courts to review. Second, there have been several recent cases where executive decisions have violated the implicit contract that I have described, that is, conditioning wide discretion on transparency, detailed explanation, and the observance of democratic norms. We've had changes in statutory terms and timings of the Obamacare statute, its insurance mandates for both employers and employees, made completely by surprise, in one case by a web posting. The OCR, Office of Civil Rights of the Education Department, its guidance to universities that they should relax burdens of proof in she said, he said cases of sexual assault came as an out-of-the-blue "Dear Colleague" letter. In cases such as these, and there are others, we have no notice, no comment, no public participation, and in many cases, I would say, very little explanation other than asserting the administrative convenience of the government. Third, We have another, I think another implicit barrier has been broken in several of President Obama's extra statutory actions, which is that they may be excused and in a larger sense legitimated as a political matter when undertaken out of necessity during a crisis or emergency. The Bush administration in 2008, during the financial crisis, used statutory authorities with enormous liberality, to put it kindly, to rescue some firms, not rescue other firms, arrange forced mergers, shotgun mergers with other firms, and then to fundamentally change the terms of the TARP statute in the fall when Congress finally got into the act. But now we are seeing such statutory extemporizing by the President and executive agencies in essentially normal times. And I would call several of those in the Affordable Care Act rollout, in the case of the immigration decision last fall, the Yucca Mountain case, which actually did end up, at least some of it, in court, as the kind of ad hoc executive branch, just clear, I think, lawmaking that we have seen before in emergencies, but now is becoming a practice outside of emergency times. These developments are the background to some intriguing stirrings in Congress and the Supreme Court. It has been mentioned several times, the Chief's concurrence in the Arlington, Texas FCC case, and now this past month, these remarkable two decisions by Justices Alito and I would say especially Thomas in the Amtrak case. Justice Scalia has somewhat different views, as has been pointed out. He's been pretty quiet on the subject since his lone dissent in Estrella. But I would say that we've now gotten pretty explicit invitations from 3 justices to bring some new cases up. And I would guess that it looks a lot like the same old 4-4-1 split. However, one never knows how these things are going to go. We just heard in the last session about a very interesting case involving taxation. Michael Grieva pointed out to several cases where executive agencies have outright plenary taxing power, where the delegation arguments, strictly formal ones, are a lot stronger than they are elsewhere. Justice Scalia has complained that there's no way for courts to draw useful lines in this case. But I think the taxing cases, and I read Justice Thomas's concurrence in the American Railroads case as essentially pointing out through an analysis of the Hampton case and other pre-1920s non-delegation cases. It's essentially a very well-crafted brief for somebody to pick up and bring around. I think in the background here is that the activities I've described are that there's a dawning realization that affects not just the non-delegation issues, but also the Chevron cases and other cases of deference to the administrative branch. And in the case of Chevron, if you listen to the explanations, deference to the Congress itself, I think there's a realization on the part of a lot of judges that these cases are based on a fallacy of composition. Especially in the non-delegation cases, the court has always assumed that Congress would jealously guard its own constitutional powers, that where it decided to delegate a certain amount of discretion under some of these powers, it would do so only for very strong and sufficient policy reasons in almost all cases, except if they just kind of forgot one day, or they were stampeded, or in cases such as the New Deal, where they were temporarily in the thrall of the president and were doing his wishes. But it was just very, very minor cases like Schechter that the courts would have to step in. Chevron was often said that we have this rule of construction, and this permits Congress to legislate, because it can choose whether it wants to give a range of discretion in interpreting the law, or simply a point, and it now knows what we're going to do, so it can make these decisions. In fact, that is not the Congress we have today. We have a Congress that, in part because of these doctrines, but in part because of important social and technological changes, has discovered a means of avoiding its central responsibility of collective decision-making, of legislating, of making actual hard choices which involve negotiation and compromise of people that have very different interests and values. That instead when there's pressure to resolve some issue, you could simply declare yourself in favor of clean air or against discrimination against the handicapped, set up a program, be done with it, and then become a bunch, not so much of legislators as courtiers to a crown government, an atomistic legislature mainly made up of individual activists who depend not so much on the home folks as to national constituency groups for support, and who are highly paid, not highly paid by any means, but until they get out, but privileged lobbyists with a public badge to lobby and affect the decisions of the administrative state. What we have today is a government where the executive fights for it's a hierarchy. It fights for its rights. It pushes the envelope. It guards things jealously. The legislature does not. In fact, it cooperates in the game. This realization, I think, opens up prospects for changes in judicial doctrine. In the Congress, we have a slew of APA reform measures. Many were passed just by the House before the elections last year, have a very strong anti-Obama cast to them. Everybody knows they weren't going anywhere in the Senate, much less had a chance of being passed. So they're very, very highly symbolic. But the Congress is now getting more serious. They actually can pass things. If they thought about it, they might even pass some things that the president would sign. There are some significant reformers among the Democrats, so that I think that some of the proposals to take some category of guidances and interpretive rules and move them into rulemaking, for having higher evidentiary standards, and sometimes even live hearings for major rulemaking proceedings, have some chance. The trickiest, to people of my way of thinking, the holy grail, is to come up with an APA procedure that permits parties with tangible, immediate harms resulting from specific agency abuses to obtain hearings before ALJs who are independent institutionally of their agencies or before district courts. My diagnosis, however, requires more than a change in the internal procedures of the administrative state. It requires calling in the cavalry. We have Article 2 is taking over everything. We have to get Article 1 and or Article 2 back in the game. I believe that Congress is simply institutionally inadequate to participate in the reforms that I have described. Certainly our current highly dysfunctional non-legislature cannot do it. It's starting to legislate. Things are starting to gel in many areas. Congress is starting to take back some of its constitutional powers. It's starting to adopt regular procedures. But even if it reformed itself, even if we did away with the filibuster. Even if we came back to a strong committee system that displaced the current partisan system, Congress has simply created an engine of lawmaking that is too vast, that is too efficient, that it operates at too high a volume for the legislature bound by the intrinsic limitations of representative committee decision-making and those added by the Constitution. It simply cannot keep up. The REINS Act passed twice. It was highly anti-Obama, but this was the way that Congress was going to take back its authority for rulemaking. It was essentially going to convert rulemaking, final rules, into legislative proposals. I mean, that's essentially what it was going to do under privileged fast-track procedures. Just look, since the new Congress took over, at the enormous energy that has been expended on coming up with similar procedures for the Iran treaty negotiations and how they affect American sanctions, and now for the Trans-Pacific Trade Agreement. Under REINS, that would happen at least 10 times a year, and more likely 20 times or more. Moreover, a piece of very, very expensive and contentious legislation would arrive at the Congress at the time of the president's choosing, in the middle of an important nomination proposal or a showdown over the budget, and it would commandeer the agenda and move right to the front of the line. I'm quite certain that the more the Republicans that are in control of the House and Senate think about this, now that it actually is something that might happen, especially if their party won the election next time around, I think that they are going to back off. And other proposals, they have proposals that look a lot like the Phil Hamburger idea. They have commissions that will go through the CFR and recommend revisions, kind of like a base closing commission. But again, it would take decades for anything to happen. This leaves me with the courts, and I'm behind schedule, but I'm finally up to the line of scrimmage, and I'm just going to keep plowing ahead. There are many proposals to beef up the arbitrary and capricious standard, to overrule the Chevron doctrine. I think that means just going to the section where it says courts shall say what the law is, maybe underlining it and putting it in italics, something like that. There are many proposals like that. To my way of thinking, they are too lexicographic to deal with the problem that we have. And my proposal is that we replace the arbitrary and capricious standard for a substantial set of 553 rulemakings with an explicit cost-benefit test that would go something like, on challenge, an agency would have to make a reasonable demonstration that a rule's expected social benefits justified its expected social costs, plus that it had chosen among the alternatives before it the one that had the greatest net social benefits, and would have one other criteria that I'm going to leave for later. I would have it apply to all statutes, and in some cases know that I would have to go in and make revisions where statutes unambiguously rule out considerations of costs. They might make exceptions in some of those cases, or they might revise the statutes in others. I want you to notice what I'm doing here. This proposal goes with the flow rather than against the flow of the powerful dynamics of the administrative state that I have described. It involves delegation from Congress to others to make the hard decision. It embraces the idea of rationalization that's not really in the APA as it's written, but that the courts have made a very, very important part of administrative law. It employs rationalization by taking the fullest and most formal kind of decision rationalization. It involves specialization. Economics is a specialized social science, a very successful social science. People have a particular language and they have methods. And it promotes transparency. the purpose of cost-benefit analysis is to simplify and explain a decision for consumption by somebody who is not an expert. So it goes with the flow, but it turns things around to work on the problems that I have identified. First of all, it brings the courts in to a larger disciplining role over the administrative state. The courts are set up for case-by-case decision-making in a way that the legislature is not. They deal with questions not unlike those that would be presented under the provision I have, for example, in antitrust law, in some areas of regulatory law, such as SEC law, following the Business Roundtable case of a few years ago, in damage calculations, in commercial law and contract cases. It would, I think, as best as we can, introduce a resource constraint into executive lawmaking and taxation. That is, decisions would be constrained not by a budget, not by not by the opportunity cost of not doing something else, but it would be constrained by the ability to make a plausible demonstration that the benefits are worth the costs. Otherwise, you cannot force the costs at all. And finally, it would turn around it would address the problem that I called that of specialization. Economists are specialists in generalization. What they do is try to take a complicated situation and try to understand where the general public welfare lies. And it would address the problem of mediocrity, which I called the problem of crumminess, by establishing clear standards of performance where regulation passed muster. We would have a baseline we would have a baseline of predicted performance to judge the actual results of the policy against. I want to give 6 quick elaborations of these points and then focus on a general problem. First, we are dealing with precedent here. We're not going against things that we have observed practicing politicians doing. The standards that I have described have been the executive order standards that have been embraced by every president from Ronald Reagan through Barack Obama, almost in the exact words of the statutes. There have been more Democratic and more Republican versions in a few respects, but the essential core standards have remained the same. A cost-benefit standard for the APA passed the Senate in 1982 by a vote of 92 to 0. It was a Republican Senate, admittedly, but there were many Democrats in the forefront. I was working in the administration then and spent a lot of time with Senator Carl Levin on the matter. We had some disagreements. We worked on language and so forth, but he understood. He understood that in one area of regulation, some legislatures want really strong enforcement, and others want weak enforcement. And another program, you get another constellation. But if you ask all of the legislators as a group, what is the rule for enforcing all of these vertiginous laws? The idea that we should be as cost-effective as possible in pursuing the missions of each individual agency is not a bad consensus standard, not something that people can agree upon. Secondly, the executive order programs have been marginal at best in their effects. They have culled out a few really bad regulations. They have ended up promoting some really good regulations. But the political pressures that are brought upon the White House, the administration, the agencies, often overrule OIRA. When I was there, when Cass was there more recently, OIRA has approved lots and lots of regulations that it didn't think came close to being cost beneficial. If the cost-benefit standard were something that was not going to end with a negotiation between OMB and the agencies, but then was going to go to an independent court where we would have eventually an accumulated line of precedent with how interpreting the standard in various kinds of health, safety, environmental, financial, social welfare, cases involving questions of ethics and many matters of that are economically indeterminate. If we had a range of these cases, in the end game, the White House and the agencies would not be writing a press release. They'd be writing a brief. And they were going to have to actually take the results of their assessments and bring it before an independent branch of the government, as has happened in antitrust since the 1980s, as is happening in the SEC in recent years. This would change the internal dynamics of the executive branch. They'd know that they were dealing with a serious test. Economic staffs would be beefed up. Economists are good at things that politicians and those that run missionary agencies. I don't mean to be critical when I say missionary. I mean you have a job. You're supposed to promote women in sports or clean water or one of 100 other good things, and that is your job. The economist is good at many things. One is thinking of how this good is in terms of its costs, which means things that will not be done elsewhere in society, at doing things such as discounting future costs and benefits for comparison, estimating the value of non-market goods, recognizing the fact of life that demand curves are sloped negatively. That is, if the price of something goes up, the amount consumed goes down. My AEI colleague Herb Stein once said, in 50 years of Washington, what he mainly did was tell politicians something that their life consisted of denying, that if the price of something goes up, the amount consumed will go down. It would improve public debate. And it's important to understand, I've seen many cases that are just, there are a lot of uncertainties in cost-benefit analysis, but there are many, many cases where you look at something and it's not even close. It's not, if you work it through, we are spending billions and billions and billions of dollars for essentially evanescent, close to zero benefits. In other cases, the low-hanging fruit problem, you can see enormous benefits and know that you just need to race ahead on this problem. The lead phase down from many years ago was a case like that. There are a lot of cases where there are tremendous uncertainties, where there are going to be differences of opinion based upon methodology, philosophy, one's attachment to a particular cause. And in those cases, that is not an argument against cost-benefit standard. That's exactly the argument that we should be having. Currently, the debates can be sly, they can move in one direction or another, but if we have a cost-benefit standard, it forces the debate in the face of uncertainty on the important subjects. Right now, some groups in regulatory proceedings, they just want to talk about the benefits, and other groups just want to talk about the costs. I want a series, I want a program where the American Timber Association has got to talk about the benefits, and where the Sierra Club and Friends of Wildlife have got to talk about the costs. That is a much more robust debate than the kind we have. This would summon professionalism of the kind that lawyers have, because when we're lawyers in the government, we belong to a fraternity that has norms of its own, a reference group that has standards of evidence and argument, of conduct, the kind of thing that has kept the OLC a relatively independent office within the executive branch. There is today a tremendous literature on cost-benefit analysis in the whole range of regulatory decisions, taking on questions of valuation of aesthetic benefits, for example, or whether jobs lost are a cost or not. There are huge volumes. Stanford Law School has probably published volumes of articles on these subjects. For example, in recent years, two of the most controversial Obama administration sets of decisions have been its energy efficiency regulation, setting appliance standard, air conditioner standards for the United States, that kind of thing, having fabulous benefits, enormous benefits. We wouldn't have needed the stimulus program given all the benefits from these programs. None of them benefits from public goods. Tiny, there's some benefits, they say, greenhouse gas and so forth, but it's mainly because people are making bad decisions and we can make better decisions for them. People don't know how to discount the future, and we do, and they're going to discount it at this rate. The fine particulate matter decisions of the EPA, in many, many cases, the big driver of air pollution regulation today. Those two areas have been subject to my way of thinking, devastating critiques, not coming out of the Cato Institute or the Mercatus Center, coming out of the Brookings Institution and Resources for the Future. It's really it's a really interesting literature, but it's an academic literature. Nobody's listening. It's not like a literature about antitrust law where part of the audience is judges and clerks and people that are going through law school who could actually make a difference. If regulatory decisions were actually part of a culture that was to some degree a professional culture of criticism, evaluation, and open debate for the courts to draw upon, it would be a big plus, and it would actually change the way things are debated back in the Congress. And I want to conclude, but I will say that I think that a test such as this is a good way to help the courts walk back from Chevron and other, in my view, excessively deferential doctrines of review of administrative law by giving them a clear mandate from Congress, which continues to tell us is really in charge, for them to work with. The problem for me, because I'm a fairly libertarian fellow, is that the dirty secret is that cost-benefit analysis is not economics. It's not my kind of economics. It's not economics at all. It's decision analysis. And in fact, if you look at its origin in the Army Corps of Engineers and so forth, it's actually a procedure of justification. And there are an infinity of government interventions that you can justify with cost-benefit analysis based upon assumptions about consumer irrationality, producer oligopoly, dysfunctional norms in need of government nudges, the social benefits of redistribution, and so forth. For that reason, because I would like to confine regulation personally, I would like to have a provision in the law similar to that in the Republicans' executive orders, which is before you get around to cost-benefit analysis, you've got to demonstrate a market failure, or some more relaxed, homey words such as you have to identify the problem that you're trying to solve, and say why it's a problem that government and coercion and uniform rules are likely to be better than variegated private decision-making through markets or through mores or through individual decision-making. I want to, if I'm around and somebody asks me, I'm going to want to put that in. If it's not there, and a lot of people would not want it there, I'm still willing to take my chances because I still think that there's a good chance that this would give us a much more fully formed, rounded debate over regulatory policy. I mentioned some of these criticisms. The energy efficiency standards, which are explicitly paternalistic. The Secretary of Energy said, we are saving consumers from making dumb decisions that they'd otherwise make. That's why we're doing this. And the criticism of this literature, the criticism of this decision and its implications for other areas of policy have been very, very powerful. And I'm happy to submit this to any three judges and let them look at it as compared to the current situation, which is it's essentially over unless you can make an argument from the statute, and no argument from the statute that the 2007 energy statute is going to succeed in court today. While I did this, I would also put in a 15-year sunset on all new rules. This again is somewhat popular. Business people are always saying they want to go back and review all these bad rules on the book. Legislatures, Congress has sometimes put in sunset provisions on its own statutes. They've been completely ineffective. They've been ignored. They've been repealed. You can't tie a future Congress. You can tie a future administrative agency a little bit more. And I noticed that almost all of the administrations have wanted to do retrospective, go back and look, and we're going to clean the CFR of all these stupid, obsolete is the word, these obsolete old regulations. And President Clinton had a program that his vice president, Mr. Gore, oversaw, and President Obama has had a similar one. The current Congress, the Republicans have some proposals for having statutory look-back provision. One of my senators, Senator Warner, loves these things. I don't really care that much. I think that old rules, they basically fade away because people adapt to them, and people found all sorts of ways to work around them in ways that make them much less costly. They become technologically obsolete, so nobody's paying attention. Product standards often simply are migrating from one level of technology or consumer preference to another. You could abolish the airbag standards today. You think people are they're going to take airbags out of cars? Of course not. It's an important part of what is now a central element of competition among cars, which is to make them safer in many respects. Nevertheless, I see in the political world, and I'm trying to go with the flow here, a lot of people want to go back and look at old regulations. So I'm really following Peter Shook's lead in his book here. By combining a cost-benefit standard with an expiration date, it means that agencies have to go back and evaluate what the actual experience has been. They've given us a hunch of what they thought the costs and benefits were. Now, after a decade's experience, were they right or were they wrong? Maybe the benefits were more. Maybe there were other changes in society that made them obsolete. So we can clean things off out of the CFR. But the more important thing is to promote a culture of experimentation and continuous openness to new evidence, with the discipline of a sunset date, so you actually have to decide whether you want to revive this rule or move on to other things. So those are my proposed reforms. Thank you for listening so patiently. If we have a minute or two, if people have any questions or complaints, I'd be happy to take them. Thank you, Michael. My aim was to go on so long, so there was no time for criticisms, and we could just go right to dinner.
One short question. In promoting more efficient and effective regulatory programs, what are your views about the efforts to prod agencies to act in areas where they're not acting?
I'm sorry.
In your effort to bring more rational decision-making to agencies, one of the things that's been talked about often by a number of scholars when he was the head of OIRA,
John Grant
proposed, and administrative law scholars have proposed, needs to be some mechanism to force agencies to, kind of look more comprehensively
Right.
at the problems that are out there and make decisions about which ones are the ones we can get the most bang for our dollar from in terms of regulation, instead of just reacting to particular problems that come on the agenda for one reason or another. So action prompting measures in a 21st century APA.
Yes.
Do you have any thoughts on those?
I'm really glad you raised that. And when I put this down on paper, I'm going to get into more. I will address that because I think that it's a good idea in general. I've had long-standing debates with other people in this space that think I'm wrong, that think that agencies are too aggressive in promoting their missions, that actually they're sluggish and they're held back. I think that overregulation is the systematic problem, but I don't deny that simply miscast regulation or not going up against problems in the correct way is a major one. The examples of outside interventions like that so far have not been strong. The most conspicuous case was Elena Kagan's tenure piece. Bill Clinton's FDA teenage smoking regulation. I mean, he really cared about this. The FDA didn't want to go close to smoking. They just thought that was a bureaucratic problem. They didn't want to touch it. And he called those guys in. He told them what to do. He gave them deadlines to come back to him. Gave them the contours, and it lost because they didn't have the justification. But it produced a statute, and they now have at least some authority. But it was something that the agency didn't want to do. There have been many cases when I was at OIRA that we pointed the agencies to. They were kind of like prompts. It was like the agency wanted to do A. We were being reactive rather than proactive. They'd want to do this and say, look, you can do the same thing in some other way. I mean, Chevron was in part the Chevron case, as opposed to the doctrine, was in part that. I don't know that John's prompting idea produced a lot of progress, but I think that as a generalization, I think that it is likely that agencies ignore things that they could be doing that are much better, that pursue their missions that somehow don't fit with their siloed politics. So it really fits with what I'm saying.
First, thanks thanks for plugging my book. But more important,
I was hoping that would keep you from standing up and shredding my talk.
Well, I'm a little more dubious than you seem to be about the ability of courts to review cost-benefit analysis. At the risk of offending the judge, I think the courts are not very well equipped to do this. So one argument you might be making is that the mere threat of reversal would itself discipline the agencies to conduct those analyses more rigorously. The other thing might be the need to alter the court's staffing or other aspects of the judicial branch in order to equip them to do this. So I'm wondering if you've given that much thought.
I haven't thought about the resource issue, but no, I believe I'll just disagree with you there. I think that a lot of the frustrations that courts, if you read the benzene case, remember the benzene case? I think it's like 40,000 words. I mean, it's just a lot of the frustration they have is that that the agencies are just throwing a ton of stuff, scientific data and extrapolations on different models and criticisms of this and that, and it's all very desultory. And I think that the cost-benefit procedure on regulation originated in the executive branch, not because economists staged a coup at the White House. It was because political operatives at the White House heard that there was something going on at DOT. They got a call from a congressman, or somebody was mad, or somebody heard back home, what's going on over there? And the DOT people had to come over to the White House and explain to a non-specialist in a few minutes what were the stakes here. And it basically was, how much is this going to cost? What are we getting for these costs? And who's complaining? So I think of this as a way of organizing for generalists. I want to bring generalists into the game. I don't think that our generalist Congress is quite equipped to do this. I think that judges are, and if you look at some of these financial cases where we have something approximating, at least it's actually an economic effect upon capital formation and financial markets and so forth. It's a standard like that. I don't see the courts having trouble with it. And in a lot of cases, what you have is a fair degree of agreement on costs and some agreement on benefits, but a lot of uncertainty about benefits. And so you have to characterize them in a certain way. Is it worth it? And in a case like that, the agency simply has to identify to a judge, we think under the statute that achieving this degree of benefits is worth this cost. And here are 6 or 7 reasons why we think so. No, I don't. I think that they've done an okay job in antitrust cases. There are commercial damages cases that are quite technical, and I think that some of these things like discounting, I think even a congressman can understand discounting if you really explain it. Look at this. None of these reforms is going to be cost-free, not for the agencies, not for whichever of the other 2 institutions in the Constitution we summon to play a disciplining role. And one has to do a little cost-benefit of one's own at the beginning to come to the view that the problems here are sufficiently serious that a more costly decision procedure, which is going to involve either the courts or the Congress, we're going to have to do. And if we don't, then as the woman who's the spokeswoman for the State Department would say, what's your alternative? If you don't have an alternative, you can't beat mine. I don't think you're completely content with the current state of of administrative law, and so the question is, what can we do? This is my formulation of the thing that seems to be most consistent with what is happening, most politically possible, and most practical in execution.
Our time has run, so please
Join me in thanking